Before we even get 30 seconds in, we already know exactly where this is going: confusion, denial, and the legal equivalent of watching someone try to fix a broken toaster with a banana. Stay with me, it gets chaotic fast.
Chaos.
Okay. All right, Mr. People versus Lanto.
Your Honor, James Kazicki, I'm asking the court right now if I could withdraw on this matter. I don't think I could adequately help Mr. Lanto in his legal arguments because I'm not familiar with the issues in it. And I'm just asking the court if I can withdraw.
Quick reminder, when a defense attorney tries to withdraw this early, it usually means one of two things: the client refuses to cooperate, or the client thinks YouTube videos count as legal training. So far, looks like option 2. Question for you guys: if your lawyer bylaid before the case even started, would that be a red flag or the red flag?
All right. Then Mr. Lanto, then I can appoint a different court-appointed attorney.
Well, I just want to clarify and make sure I'm going to be able to speak for myself in the court. I don't want anybody speaking for me. As a matter of fact, I mean, all I really want is...
Translation: I watched a TikTok and now I believe I'm legally invisible. Every sovereign citizen hits this stage, demanding independence while literally standing in a courtroom because they couldn't be left alone.
So that's first and foremost. And then as far as an audio-only recording, I was told that there's an objection to the audio-only recording, and I'd like to know, I don't feel safe without a recording, so is there any reasonable objection?
Well, first off, you can't record in the courts of law. They're already, if you'd like a transcript, everything is already being recorded by my court recorder. And I can assure you that there's no, the recording device is on and it records, and that's what she does. She records everything. So if you'd like a transcript of that after the proceedings, you're more than welcome to order a transcript. So
I've been told that before, and then when it comes to getting the transcripts, I still am waiting for the transcripts when I was told that in the past. So well, like I said, I don't feel safe without a report.
I know that you're not talking about the 23rd District Court, because I know if you've ordered a transcript from my court, those are always forthcoming. I've never had to deny anybody a transcript. So well, if that happened to you in another court, then I suggest that you call the State Bar of Michigan and report that court, because obviously they're not doing things correctly.
Well, yeah, I have no desire to do that. All I want is to have fair and meaningful hearings. And well, I mean, first off, I'd simply just like to be left alone. But other than that, I mean, to get fair and...
I get that, but obviously you had an interaction with somebody where they are alleging that because today's date and time set for the arraignment. So I want to make sure that you understand. I need to file. On the date and time in question, it is alleged that, because first let me do the arraignment part, because I need to let you know what exactly you're being charged with. All right. So you say you want to be left alone, but they are claiming that there was an interaction. Now, first off, you do have the right to remain silent. Anything you say can and will be used against you. You also have the right to an attorney if you got a 411 will be appointed to you by the court at public expense. Now, it is alleged that on November the 17th of 2022, while in the city of Taylor, that you violated City Ordinance 32-31, which is a charge commonly known as interfering with the police authority. That is a misdemeanor punishable by 93 days in jail and or up to $500 in fines. So, as to that charge, how do you plead?
Quick legal clarification: transcripts aren't optional, they're part of court records. If he truly requested one, he'd get it. But sovereign citizens love using paperwork conspiracies to avoid accountability. It's part complaint, part strategy, and 100% nonsense.
Possibly difficult.
Well, first, can I just make a few clarifications?
I'm going to caution you that anything you say can and will be used against you. So
I understand.
As to guilty or not guilty, that's just the only question I'm asking right now.
Well, in order to say guilty or not guilty,
or you can stand mute, which means I'm not saying anything, and then I will enter a plea of not guilty for you. so that you don't have to
Okay.
say anything and it automatically goes to not guilty. So are
Well,
you pleading guilty, not guilty, or standing mute?
Well, before I make a plea, you stated that I have the right to be informed of the cause and nature of the charges.
Right, which is what I just told you. I just told you what the charge was.
Okay, and you're stating that it's based on an interaction. So my guess is that you have no firsthand knowledge of anything that happened.
Well, I'm not stating anything. All I'm telling you is what the people of the city of Taylor have charged you with. They have charged you with a violation of City Ordinance 32-31. That ordinance is commonly known as, by name, as interfering with police authority. I'm not putting any allegations. I'm not stating any facts. I'm merely stating what has happened to get this case into my courtroom. That's it.
What? You sound awfully fair to this point, and I certainly appreciate that. Because, yeah, and just to be specific, it's not the people of the city of Taylor, it's David Jones, and then I don't know the name of the prosecutor, and I just want to make sure that the prosecutor is aware of, Section 241, Section 242, Title 18, deprivation of rights under color of law. I want to know if they're aware of that.
Well, first off, that's a separate, what you're talking about is civil type cases.
Well, it's also criminal.
So what I'm saying is, in this matter, the matter that is before me, okay, is a misdemeanor matter where it is alleged that you violated an ordinance of the city of Taylor. The people of the city of Taylor, through their attorney, have acted to bring a case against you. So the only thing I can do right now is ask you, are you pleading guilty, not guilty, or standing mute?
Can I have the name of that prosecutor that's bringing the charges? Because I've had in another case where a prosecutor stated at 3 proceedings away from the arraignment, she stated that after reviewing the video and speaking to the witness.
I'm going to take your response as being non-responsive, which is
Well, I
has
object to
nothing
that.
to do with being guilty or not guilty. So I'm going to enter a plea of not guilty for you.
I object to that.
Then are you guilty or not guilty, or standing mute? Those are the 3 things we got going on right now.
Well, I first have to clarify. You did say that I was presuming.
I don't have to clarify anything, sir. I'm being very fair with you. And right now, you're basically splitting legal hairs. Right now, the only thing that I have jurisdiction over is do an arraignment. Nothing more can happen in this case until the arraignment happens. And the arraignment is whether or not you plead guilty or not guilty. And if you're unresponsive to that question, then I'm going to enter a plea of not guilty for you so that I can protect your constitutional rights, because a lot of people don't know that they should. So that's why I enter a plea of not guilty for people who don't really know how to answer the question. So that way they're not getting, no one's going to be bamboozled or said that, well, you said guilty and you didn't know what was going on. I don't want that to happen. I say that you're either going to plead guilty, not guilty. If someone is unresponsive to that question, then I automatically just enter a plea of not guilty for them so that they can preserve all of their rights to a trial and everything else without having been forced to be pleading guilty. So by you saying everything else, that's all well and good, but it's not the time and place for it. See, that's the problem, is there's a time and place for everything in the matter of procedures of courts. And when you just start trying to jump the gun and go right from 0 to 60, that's not how it works. There's a stepping process, and everything has to go in that process. And the process today is an arraignment. It's just an arraignment where I'm telling the individual who is alleged to be a defendant what the allegations are. And the allegation is that you violated a city ordinance, and that city ordinance is basically one commonly known as interfering with the police authority. So that's and letting you know what the charge is, and letting you know what the penalty for it is. And I've already stated. So again, I'm going to ask you, guilty or not guilty?
Well, I certainly appreciate the explanation. It seems I don't know. I mean,
I'm not getting angry, sir, but I'm literally stating that nobody's trying to bamboozle you or anything like that. I don't know what happened in some other court, and everything that you want to do, you can still do. I just need to know if you're pleading guilty or not guilty. And if you're not answering that question, then I'll enter a plea of not guilty for you so that it preserves all of your constitutional rights and the case still moves forward.
Right. You said we're interested in preserving my constitutional rights, correct?
That is correct. That is correct.
And then one of those.
What I'm saying is everything that you're saying can be used against you. If you think that you have a motion to dismiss That's something that you can do, but that's when the case is already going to the next stage, which is
Well, like I said,
of not guilty for you.
Well, like I said, I would just prefer to be left alone and not have to come back at all. And then if we're not going to do that, then I definitely like to have fair and meaningful hearings. And my concern is we've got a police officer and we've got a prosecutor, both are state actors, and they're trying to bring charges against me. And I just want to know, because you are a judge and you are another state actor, am I going to get a fair and meaningful hearing?
And I'm telling you that I keep right here, hang on one second. Right
And
copy of my, sir, please, I have not cut you off at any point. Please don't cut me off. This is a copy of my oath of office. And why do I keep it here? Because it constantly reminds me that, what am I going to do? I do solemnly swear that I will support the Constitution of the United States and the Constitution of this state, and that I will faithfully discharge the duties of the office. So I take that very seriously. My son serves in the Marines. He takes his duty to uphold the Constitution seriously. So if you are implying that I am not going to uphold the Constitution, or that I am going to take an oath and not be true to my oath, then I take offense to it. So if you sense any sort of anger, there's no anger. The only thing I'm telling you is that you are implying that I somehow am an oath breaker. And I am not.
Well, I didn't. I didn't.
That's exactly what. I swore an oath to the Constitution that I put my hand on the Bible and swore to. And I'm telling you, I don't break my oath.
Okay,
So
would you
now,
agree
if you're implying that you're not going to get a fair hearing? That's my job, is to make sure that fairness happens, that due process happens. And so, so I'm asking you, just as a matter of course, because this is the stage that we're at, is an arraignment. Are you pleading guilty or not guilty?
Well, you just said.
Or if you're not responding to that question, I'm going to enter a plea of not guilty on your behalf, and I'll find you standing mute to the question.
Well, I object to anybody making a plea on my behalf, and I just wanted.
I'm not making a plea. I'm just finding you. I'm just entering. I'm just saying that that you are right now presumed not to be guilty, because that's just your constitutional right to be presumed not guilty.
And then that means
your constitutional right. I'm not entering a plea for you. I'm just listing you as somebody who is right now not guilty, because the Constitution says you are to be presumed not guilty until proven guilty beyond a reasonable doubt. So I'm not entering a plea for you. I am just merely stating that this individual is to be treated as someone who is not guilty.
Okay, and then, so if I'm presumed innocent of all the elements of the charge, correct?
No, you are presumed innocent until proven guilty, and you haven't had a trial yet. That's your other constitutional right. So we can set this for a trial.
Well, we just said that I'm presumed innocent until proven guilty, and then my question was, am I presumed innocent of all the elements of the charge? And I didn't get an answer to that, because that's a yes or no.
Well, first off, I don't need to answer questions, and nor am I going to give legal advice, because that would be more legal advice that you would talk about with your attorney. And when I'm wearing the robes, I can't give legal advice to either side. I'm more like a referee. I can throw a penalty flag, I can call a whistle for a violation of a rule that I see one side doing or the other side doing, but I can't coach either team.
Well, I certainly appreciate you being fair. Yeah, because
the answer to your question is I can't answer your question, because that would then be giving you legal advice, and I'm not allowed to give either side legal advice.
Okay, because in this particular case, there are crimes that occurred, but the crimes that occurred were the people that put their hands on somebody that had no desire to be having somebody put their hands on them, and then binding them, and then placing them in the back of a gangmobile, and then taking them to a cage. That's the victim in this case. And the victim, if the victim is going to be the city of Taylor, and it's going to be presided over by a judge that is paid by the city of Taylor, with a police officer that's bringing the charges with the help of an attorney, and then they don't know what 241 or Section 241 Title 18 conspiracy to violate my rights, then I have serious concerns for the fairness and the meaningfulness of this.
This is the part where everyone watching should take bets. Does he answer the question, dodge it, or start reciting sections of the Constitution he's never actually read? Drop your prediction in the comments, guilty, not guilty, or sovereign citizen meltdown. And there it is, the judge finally does what every viewer has been waiting for, takes control. When a defendant refuses to cooperate, the court steps in to protect due process, not for him but for the integrity of the case. Chaos meets reality.